Hello students, welcome back for the course of MBA Semester 3 Human Relations and Legal Framework. Today is our lecture number 16 and the topic of our today's discussion is laws relating to the termination, discharge, dismissal and suspension of employees. So the primary objective of our today's session is to help to understand the laws or what exactly the provisions which has been made under the different labor laws which are being related with the termination of employees, discharge, dismissal and suspension of employees. So the contents of our today's session are termination, discharge, dismissal, suspension and laws relating to the termination of employment. So first of all we are talking about the termination of employees. Termination of employees is nothing but the removal of employees from the workplace or whatever the employment premises wherever the worker has been working, either he has been voluntarily left the job or it has been removed by the employer in the process of layoff and retrenchment. So that layoff and retrenchment has been defined in the Industrial Dispute Act 1947. So whenever we are talking about this termination of employee, that termination means the end of job, okay, the end of service. So that termination either it should be voluntary or involuntary, okay, that should be defined on the basis of different parameters whenever the termination of employee will go exactly, okay. How does that exactly goes? Either the employee will be fired in the organization due to his or her non-performance, so he will be asked to quit the job, or they have been laid off during the from that particular course of employment. So when anyone is no longer working, the employment will be terminated, okay. So maybe this termination of employee could be also happen due to some unpardonable reasons, okay. That may be related to the breach of trust, okay, and embezzlement. So there may be a different sort of the non-performance related activities by any a particular employee, those who are not complying with the compliances of that industrial establishment, and the employer has been not satisfied with the performance of that respective employee, okay, their employment would be terminated. So prior to the termination of the employment, the employer should have to give the minimum notice of 30 days or 90 days to that particular employee. There may be some different causes of terminations, okay, and say for example, if the employee remains absent from a long period of time, okay, suppose there is a problem of absenteeism, and due to which the production process will hamper, okay, this will be absenteeism will be a serious cause of misconduct, okay, by means of that particular employee. So they are being asked to terminate their jobs, okay, or maybe they will be retrenched or lay off from their jobs. Termination is nothing but that we will discuss earlier, okay. It can be also defined if it is the end of service contract. So according to the Industrial Establishment Standing Order Act, okay, once it has been mentioned in the standing order and as well as in the contract or agreement in between the employer and the employee, okay, if the duration of that particular employment has been completed, then its job has been automatically terminated. So the reasons for contract being terminated could be that the employee either they will resign voluntarily or involuntarily, or it could be where to fired. Okay, so there will be two types of termination that could be there. So voluntary terminations and involuntary, wherever the workers were fired by the employer. So it depends on the kind of circumstances. Okay, and so generally, when does exactly the termination will go? Okay, during the course of employment, whenever the employee they are on the training period, or suppose say probation period, so it has been mentioned in their contract. Okay, if due to non-performance, their job will be terminated. It is necessary to specify in the appointment order that employee services will be terminated if his or performance is not satisfied. So either it should be a standing order or their contract, okay, or whatever their appointment order, okay, wherein it has been mentioned that their job will be terminated if their performance is not up to the mark. Then we are talking about say for example, in what circumstances the employees can be terminated. So specifically, we will call them as causes of termination of the employees. So we came to know, whenever the term has been completed, the expiry of the fixed term which has been mentioned in the contract, or mutual separation of the jobs and other related responsibilities, in that case, okay, the job can be terminated. Resignation by an employee, if the employee has given the resignation, then his job has been automatically terminated, either on retirement or superannuation or during the period of layoff. Okay, so whenever the workers has been laid off, okay, or retrenched, okay, in that case their job can be terminated. There will be some other cases, or some condition termination for cause, okay, wherever some particular provisions has been made to terminate the employee. So it has been established a breach of employment contract or internal policies. If any of the employees they try to breach the terms and conditions of the employment, okay, and they need to violate certain organizational rules, in that case their job can be terminated. If the employees suppose they were involved or committed any kind of criminal offenses, even in that case their jobs will be terminated. So any employee who is unable to fulfill the material obligations of the job, okay, some physical kind of activity or some extra work has been required over there, and the worker has been unable to perform that particular duties, in that case their jobs also terminated. Other than that, there will be some sort of condition that is called as misconduct. So in case of misconduct, we identify some sort of poor performance after giving the due notices to improve their performance also. So loss of confidence by the management, okay, if the management are not exactly sure about to improve the performance of that particular employee, and continuous absenteeism of that particular employee. So this can be considered as a part of the misconduct, and on what basis, okay, the employee can be terminated. Then we are talking about dismissal. So dismissal is exactly used by an employer, okay, it is done by an employer, okay, which results it into the termination of the service of that particular employee. So termination of that particular employee can be happen when there is a wrongful act done by the side of the employee. If any of the employee, okay, they has done any sort of misconduct, okay, or any sort of activity which is not in accordance with the standing order of that particular organization, okay, and it has not mentioned in the contract or agreement, then these kind of acts, okay, these are being willfully conducted by that particular employee, okay, then in that case some sort of action would be taken, okay, under the dismissal. So dismissal also means the termination of service of the employee, okay, and there will be some sort of punishment, okay, for his misconduct in that particular organization. So dismissal is nothing but a sort of punishment for any delinquent employee who has been committed any kind of mistakes, okay, or he has made any wrongful act, okay, which could not be entertained by the organization. It is also a sort of punishment, okay, against the alleged misconduct, okay, which could not be easily get resolved, okay, and it is quite necessary to take some action, okay, against that particular employee. So in dismissal there always be some sort of punishment, okay, and there will be a termination of service. So dismissal involves the termination of service as a disciplinary action. It is a tool of disciplinary action taken by the management against that delinquent employee. We came to know dismissal is an action led by the employer which results in the termination of employment. Okay, and it is an involuntary separation. So here the management of the organization, they would ask the specific reason behind, okay, what kind of wrongful act that he has been made, okay, and they will take their own decision. Otherwise the known as being fired, sacked, canned, or they are being discharged. If the employee could not find to be guilty, okay, then he will be either discharged or simply just fired. Otherwise he will be dismissed from the job, okay, and he need to be terminated, okay, as a part of the punishment. Say for example, any employee those who have been misbehaved with his superior, or suppose they will beat him, okay, this will be the part of that misconduct, okay. So once it has been identified in such cases, the employer will follow the process of dismissal, okay. So whatever has been mentioned in the standing order, okay, whether it has been appropriate or not, okay, and accordingly, okay, there will be some sort of committee would be there, and they will decide some particular form of domestic inquiries will go against that particular employee those who have been willfully conducted any kind of wrongful act, and later on he will be, suppose he found guilty, then he will be dismissed from the job. So this is called as a dismissal. Then in continuation with the dismissal, some special provisions are being also there. Dismissal is permanent in nature, okay. Once the employee has been the once the employee has been terminated, okay, using that particular form of dismissal, that dismissal is a permanent in nature, okay, unless the matter goes to the court and decision goes in favor of employee and he is reinstated, okay, in the company, okay. Particularly the employer will decide whether any wrongful act the employee has made or not, okay. So initially there will be a simple domestic inquiry can be conducted, okay. Suppose he is found to be guilty, okay, then he will be terminated. If the employee themselves, those who are being not satisfied with the domestic inquiry of that particular company, then he will approach to the court, okay. If in court, labor court, suppose the labor court found that, okay, and that the employee is not guilty and decision should be in favor of the employee, okay, the decision could be further instigated, okay, in the company, and that particular employee can be re-employed in the company. Dismissal of worker is being done after the disciplinary inquiry started against the employee, okay. It is quite necessary to dismiss any particular employee. Some sort of procedure has been laid down, okay, under the our standing order act, wherever if you want to dismiss any particular inquiry at organizational level, we need to carry out that disciplinary inquiry procedure. Once it has been found that, okay, we need to define some particular charges against that particular employee, and suppose the person is found to be guilty, then and then only the action will be taken in the form of dismissal of that particular employee. In case of dismissal, employee can be acquitted for his charges by a court and reinstated back to his job. As we were discussed earlier, okay, once any of the particular employee, okay, they win their cases in the court, and the court has been identified that, okay, the employee, okay, they are being wrongly dismissed, okay, and then only they can reinstated, okay, back to their jobs, and they can join their duties, okay, in the company. Dismissal can be also deprive the workman of his terminal benefits. So whatever form of allowances and other benefits that the workers are getting, okay, but during the period of dismissal, okay, once the employee has been dismissed, okay, they will not be allowed to provide any sort of benefit, terminal benefits, or whatever form of payable benefits has been supposed to be there. Say for example PF and gratuity, they are also sometimes it will be confiscated, or if which can be withheld by the employer. So prior to doing so, okay, wherever the management of the organization they will conduct the disciplinary inquiry and identify whether the act has been willfully conducted by that particular employee. A person who is dismissed from the service may find it is difficult to find the alternative employment. Okay, it is quite a very difficult situation, particularly for the employee who has been dismissed. So, employees those who have been dismissed, they could not find any immediate employment, and even their payable benefits which could be withheld by that particular employer. Okay, so in that case the employee could face the problem of some different economical problems. So in that case there will be some serious issue to that particular employee. Reasons for termination are that will be also called as reasons for dismissal. So when does exactly the employees can be dismissed? Either it will be a sort of incompetence by the employee, including lack of productivity, poor quality of work on account of that particular employee, insubordination, okay, with respect to the related issues, say for example dishonesty or breaking any company rules and regulations. Attendance issue means it is related with the problem of absenteeism, okay, so frequent absences or chronic tardiness would be there, okay, so that will cause some sort of action would be taken in the form of dismissal by the employer. There will be some different forms of act which can be conducted by the employees. So there will be theft, okay, other criminal behavior including relieving the trade secrets, okay, so some sort of confidential information that can be revealed by any particular employee, those can be terminated. Then we are talking about some other activities which could be undertaken wrongly by means of that particular employee, that is called as sexual harassment and any other discriminatory behavior in the workplace. Okay, so whenever the employees are doing any wrongful acts, okay, and they are being found guilty over there, so the action would be taken in the form of dismissal of the employee. Some sort of physical offenses or violences, okay, or threat against any other employee, okay, they were given to any kind of threat to the employee, so there will be again the action in the form of dismissal of the employee can be taken by the employer. Discharge, as compared to dismissal, it is just opposite to the dismissal. So in case of the discharge, okay, there will be also a termination of service, okay, but the employee could not be permanently dismissed, okay. So exactly what is that discharge is? Discharge is a termination of service by an employee, but it is not done for the punishment purpose. So in case of discharge, the employee can be terminated temporarily, okay. Then there will be some sort of investigation, okay, or court of the domestic inquiry processes will go. If it has been found that the person is not guilty, okay, then there will not be any sort of punishment to that particular employee, okay, and they can continue their jobs. Discharge is can be happen in the separation on mutual understanding between the employee and the employer, which is in line with the procedure of the organization and might not necessarily have any punishment involved. So in case of discharge, okay, it is just a simple form of separation on mutual understanding between the employee and the employer. So here the employee and employer, okay, they will be negotiated the terms and conditions of the employment. If any of the employee, okay, those who are being not able to work due to certain reasons, say for example his ill health, okay, partial or total disablement, so they will be compensated over here, and they will be transfer, or they will be replaced, okay, in particular department wherever they can perform their works. So they are not being punished in case of discharge, okay, just only some other kind of jobs those who can perform appropriately from earlier position, some next position it has been either transferred or replaced. Discharge may be the termination of service, okay, mainly on the medical grounds, okay, that could be happen due to certain ill health, okay, or some sort of diseases, okay, or some partial or total disablement, okay. Those employees are being facing some difficulty at the workplace. Before dismissing any particular employee, okay, in case of discharge, an errant employee may be served and reasonable advance notice. If it has been found that any of the employee, okay, they are in a process of dismissal, so particularly during the process of discharge, okay, that employee need to be served using some advance notices to provide the explanation within the prescribed period of time. The employer can hold a disciplinary proceeding or domestic inquiry in a proper way, okay, into that particular company. If suppose the person could not find found guilty over there, then they can continue their job, and there will not be any sort of punishment, okay, with respect to that discharge. In case of discharge, he may or may not go for inquiry, okay, that will depend on the situation. Particularly in case of dismissal, it is there is a compulsory requirement to go for the domestic inquiry by that particular employee, those who have made any wrongful act, okay. But in case of discharge, okay, if in the initial stages the employee could not be found guilty over there is no necessity of domestic inquiry over there. It has been also proved by the inquiry officer, okay, after having conducted the inquiry, we can discharge that particular employee from the service of the company. For this, we have to give the benefit of the employee like PF and gratuity and other benefits simultaneously. So suppose the worker has been discharged due to, suppose say, ill health, okay, total or partial disablement, because that particular employee could not able to perform that particular job, and that's why that person need to be discharged from the earlier position to the next position. So whatever their payable benefits has been there in the form of PF and gratuity, okay, that could be immediately issued to that particular employee in case of discharge, okay. Now reasons for discharge, okay, particularly there will be several reasons, and even also there will be the reasons for termination of the employee also. So there will be a inebriation or alcoholism, okay. If the a person, those who are being addict to the alcohol, okay, in that case, okay, the person can be either they will be discharged or dismissed. Violation of rules, some sort of physical disability, okay, if the employees could not able to perform the job. Violent and aggressive act, inefficiency by that particular employee to perform the job, unauthorized absence from the duty for a longer period of time, and dishonesty. So there will be different reasons for discharge, and even for the termination of service of employment. Then we are talking about suspension. Keeping the employee away from the workplace temporarily for the reason of discipline, okay. So there will be always a code of conduct or code of discipline in the organization. So certain group of people or employees, okay, they will be not allowed to perform their job, okay. So and they will be kept away from the workplace for a temporary period of time by giving the reason of discipline, okay, that is called as suspension or suspension of employees. Suspension of employee does not mean that okay the permanent removal from the service of that particular employee. So, in case of suspension, the person could join after some time after investigating uh, that particular issue with respect to that particular employee. If the person is suspended, okay, he or she continues to be in service. So there will be a possibility that the suspended person can rejoin the job and continue in service after the investigation. Suspension means exactly prohibiting an employee from the performing his duties or withholding his wages for a period as a punishment. Now, in case of suspension, suspension is just like dismissal. Okay, so as in case of dismissal, there is some sort of punishment with respect to that particular employee who has made any some sort of wrongful acts. So even in case of suspension, okay, the employees could be prohibited over there to perform their duties and their wages are withheld, okay, to the employer, particularly for the period as a punishment. So during the period of suspension, okay, the contract of employment between the employer and the employee is said to be under suspension. So once the employees are being suspended, it has been also mentioned in the contract of the employment in between the employee and the employer. When does exactly the employee can be suspended? It has been also mentioned either in standing order and contract. The period of suspension should not, however, be exceed the maximum period stipulated in the standing order. So, how much should be the suspension period for that particular employee? That is also mentioned in the standing order. Okay, and that model standing order could be made available to the employees also. Then there will be different reasons for suspension of the employees. So in case of suspension, there will be some sort of punishment to that particular employee. Okay, so when does exactly the suspension could takes place, particularly on account of the some sort of misconduct? If the employee has committed some serious act or misconduct, such as say for example assault or sabotages, okay, his presence inside the work premises poses to the threat to the safety of the man and material as well as the company. Okay, means the person will seen as a danger. Okay, those who can cause to the company, and therefore, okay, they will be immediately suspended from the organization. So they will be kept under suspension as immediately as possible, or their investigation will go okay according to the standing order. Now when we are talking about this suspension pending domestic inquiries, okay, so there will be a mechanism against such kind of employees, okay, those who can feel as a form of danger to the particular company, okay, wherever some sort of domestic inquiry can be conducted by the individual organizations. So at this stage, suspension cannot be called as a punishment. At initial level, there will not be a punishment. It is desirable to issue the order of suspension along with charge sheet, okay, but if it is not possible, the charge sheet must follow within 7 days of issue of the suspension order. So at initial level, okay, there will not be a punishment. Okay, once it has been investigated, okay, by that domestic inquiry or that inquiry officer, once they are being satisfied enough, okay, that particular person will be willfully doing some kind of wrongful acts, okay, which could cost to the company, then the charge sheet has been filed, okay, and within 7 days of the act, okay, suspension order will be released to that particular employee. Okay, suspension pending court order. Okay, once any kind of investigation has been conducted by domestic inquiry, if suppose the employees are not being satisfied, okay, by means of domestic inquiry, they can appeal to the court also. So the disciplinary authority has right to keep the employee under suspension. Now here the respective court authorities, okay, or whatever form of machinery for settlement of industrial dispute, they can keep any of the employee those who can threat to the company under suspension if he is accused in the court of law for any criminal offense until the disposal of the trial. So until the court proceeding goes, okay, till that particular period of time, that person or employee can be considered as a culprit, okay, and he has been committed some serious offense, okay, and he will be suspended for that particular period of time. The decision will be taken by the court, okay. Suspension as a part of the punishment. Even though the employee is not suspended pending inquiry, okay, if it is decided to punish him by the way of suspension of the act of the misconduct committed by him, okay, the disciplinary authority may do so after conclusion of the inquiry, in which case the suspended employee will not be entitled to any payment of the period of suspension since the punishment imposed on him. Now whenever we are talking about the suspension as a punishment, so on what account exactly the employees has been suspended with punishment, okay. So if any particular employee, even though an employee has not been suspended pending inquiry, if the inquiries has not been completed, if it is decided to punish him by the way of suspension for the act of misconduct committed by him, okay, the authority will decide whether they will need to punish to that particular employee, okay, by means of suspending that particular employee, okay, on account of whatever form of misconduct that he has committed. The disciplinary authority that they will decide or they will alter their decision, okay, and take the final conclusion. So in which case the suspended employee will not be entitled to get any kind of payment for the period of suspension. So during the period of suspension, okay, the employee, that suspended employee will not be get any kind of wages, okay, and it will be a sort of punishment that should be imposed on him due to some wrongful act that he has been made. So these are the various laws which are being relating to the termination of the employment. Generally, we came to know about how does the employment can be terminated or services with respect to that employees can be terminated. So we are already familiar with the termination by contract, okay, or agreement will be there. Okay, there will be a termination by law. There are some various laws are being there, okay, under which different provisions has been made, and termination by central and state legislations are there. So some central legislations and state legislation, they have been clearly specified, okay, under the different provisions under different laws. So we will listed out some important laws which are being related with the termination of service, okay, with respect to discharge, dismissal, suspension, retrenchment, okay, layoff, okay. So all these has been specified under these acts. So we were already seen about the Industrial Dispute Act and Industrial Employment Standing Order Act. We will also see some other acts which are being related with the factory, that is called as the Factories Act 1948. There will be some other important laws, okay, the Shop and Establishment Act 1953. This law would be there in our syllabus, Maternity Benefit Act 1961. Some other laws, okay, Employment Exchange Compulsory Notification of Vacancies Act 1959, okay, the Payment of Wages Act 1936, Equal Remuneration Act 1976, Rights of Person with Disabilities, okay, act which was passed in 2016. This is a recent act, okay, specifically the person, those who are being suffering from disabilities. So how does the employee can be terminated, okay, which has been specified under different provisions, okay, with respect to discharge, dismissal, okay, layoff, retrenchment, okay, suspension. All these provisions are available under this act. So we will already discuss about these two laws. Some other important laws, Factories Act, okay, Maternity Benefit Act, okay, Payment of Wages Act, okay, and Equal Remuneration Act, that we will see in the forthcoming sessions. So that's all about our today's session. Thank you very much.